Hi everyone, welcome back to Law with Dunk the Law Guy, and we're on day 15 of the Case a Day series, where at least from Monday to Friday I will go over legal cases relevant to criminal law, tort law, contract law, and the English legal system. I'll keep trying to do so at least. For day 15, I'm going to continue with the next part of causation that falls within the realm of legal causation, which is to cover things that might break the chain of causation, and then actually move on to the case of R.V. Roberts, 1971. When I teach my students the rules of causation, Mark schemes have taught me to first cover factual causation as number 1, then legal causation as 2A, and then whether there are any intervening acts which should be treated as 2B, and finally, whether there is the Finn School rule which should be treated as 2C. Remember, as covered previously across recordings on days 12, 13 and 14, when the defendant's act or omission is deemed the legal cause of the victim's death or injury, there is then a connection in law between the defendant's conduct and the victim's consequence for the most serious crimes. This connection is called the chain of causation. However, this chain can be severed or broken. There can be situations where after the defendant's conduct something happens that is deemed sufficiently separate from whatever the defendant did and can therefore break the chain of causation. The defendant might still be found guilty of a lesser crime that doesn't involve death or injury, but they are not guilty of the crime in question due to the crime requiring the rules of causation to be proven. I'll give more details on this in tomorrow's recording. The chain of causation might be broken by the victim behaving in a daft or unreasonable way, often called the daftness rule, or by the unreasonable actions of a third party, or even a natural but unpredictable event. Medical negligence doesn't really break the chain of causation, but you would be expected to explain why with reference to case law. Today, I want to explore R.V. Roberts, 1971. And why there was no break in the chain of causation in this case by referencing the daftness rule. In this case, the victim accepted a lift home in the defendant's car. During the journey, the defendant made unwanted sexual advances towards her and tried to pull her coat off. Afraid, she jumped out of the vehicle and suffered injury. The defendant was guilty at trial of Section 47 of the Offences Against the Person Act 1861, common assault that occasions actual bodily harm, which the Court of Appeal upheld. One of the Lord Justices of Appeal's judgments asked whether the defendant's reaction was a natural result of the defendant's behaviour, i.e. was it reasonably foreseeable. The Court of Appeal also stressed that where the victim does something so daft or unexpected that no reasonable person could expect or foresee it, then the victim's act will break the chain of causation. Here it's clear that the victim behaved in a reasonably foreseeable way, and so there was no break in the chain of causation, i.e. she was not daft. And that's it for today. Thank you from Law with Dunk the Law Guy, and I'll see you tomorrow.